Hello and welcome to this episode of Law for Lawmakers. I'm Fiona Rutherford, Chief Executive of Justice, the UK's law reform and human rights charity, working to create a fair justice system within everyone's reach. This podcast is based on our Law for Lawmakers guide, which helps repair the cracks in the UK's political foundations by giving every MP the tools they need to act as custodians of our democracy. The guide explains key legal and constitutional principles to help politicians of all parties and their staff scrutinise legislation, assess its legality, table and write amendments, support their constituents and hold the executive to account. But this podcast isn't just for parliamentarians. It's for anyone who cares about how our laws are made, how power is exercised and how justice is delivered in practice. Each episode brings together leading voices from law, politics and public life to explore the principles that underpin our constitutional system and the practical role Parliament plays in upholding the rule of law. In this episode, we're focusing on the role of Parliament in scrutinising criminal justice legislation and, in particular, on the constitutional importance of the right to a fair trial and trial by jury. Our guest today is Karl Turner MP, the Member of Parliament for Kingston upon Hull East, a constituency he's represented since 2010. Karl was born and raised in East Hull and is the first MP born and bred in the area to represent the constituency since William Wilberforce. His route to Parliament was not a conventional one, leaving school at 16, working in local government and as a self-employed antiques dealer before returning to education to study law and train as a criminal barrister. That experience has shaped his politics and his approach to justice. The son of trade unionists, Karl has consistently focused on issues affecting lower-income communities, access to justice and the real-world consequences of criminal justice policy. During his parliamentary career, he has held a number of senior shadow ministerial posts, including Shadow Solicitor General, Shadow Attorney General and Shadow Minister for Legal Aid, roles that placed him at the heart of debates about legality, fairness and the proper limits of state power. More recently, Karl has become one of the most prominent parliamentary voices opposing proposals to restrict jury trials. Drawing on his experience of the criminal courts, he's argued that measures designed to address backlogs and system pressures must not come at the expense of fundamental constitutional protections. This episode examines how lawmakers should approach reforms of that kind, how they should interrogate evidence, challenge executive assumptions, and use the legal tools at their disposal to ensure that change strengthens rather than weakens public confidence in the justice system. Karl, welcome. It's really good to have you with us here today. I'm going to ask you first of all around a question about your experience, your motivation. You've had a fairly unusual or unconventional approach into the law. You left school at 16.
Yep.
You had a number of other jobs and then you decided to get back into education and then into the law. Tell me about that.
Absolutely spot on. I began an interest in antique dealing. I was in Australia for 12 months on a working holiday and picked up an interest while I was there, in fact. When I got back, I began trading in antiques, bought some antiques at some point and was accused of handling stolen goods, which I didn't like very much. So I was arrested, interviewed and subsequently charged and prosecuted. And the experience really taught me that I needed to learn a bit about the law to ensure that that could never happen again, as it transpired. Of course, I was acquitted, not by a jury, by the judge, because the prosecution offered no evidence. But I'll never forget the words of His Honour Judge Tom Cracknell, who became a friend of mine when I was in practice, eventually. He said, "There's no smoke without fire, and, be careful in the future," and all sorts of other things which struck me as condemning me to culpability when in fact there was none. I was innocent. I didn't begrudge terribly the fact that I was suspected. It was part of the dealing in antiques, I suppose. But what I did begrudge is the way it was handled by the prosecution, and indeed the fact that the judge was, in my view, more likely than not to have convicted me if he'd have been sitting as a single judge, rather than that hugely, incredibly important filter of a jury of 12 men, women, good and true.
Well, I must confess, we're going to come on to juries, and I hadn't realised just quite how up close and personal this position and this legislation really has on you. But I was going to ask you, actually, aside from this case, from your practicing days in the criminal courts, is there a particular case or issue that still influences how you approach the criminal justice and the way in which the policy works in criminal justice?
Yeah, there are. Most of them, in fact, to be honest with you. My practice was as a solicitor, an high street firm, and you deal with the whole stuff. You know, you could be called to a police station to deal with shop theft. It might be a murder. But the ones that struck me was vulnerable people, whether it be people who were victims of domestic violence, and many of my clients were, because in my view, there's a tendency for those victims to end up in the criminal justice system, not as victims, but as criminals. But youths as well would be something that triggered me and made me determined to fight for justice.
So moving forward then into your parliamentary career, and we hear often about people talking about scrutiny, parliamentary scrutiny, legislative scrutiny, and it can sound quite abstract. In real terms, how have you seen scrutiny really work within Parliament? You know, how have you seen it work at its best? When is it genuinely improving legislation?
Well, I think it's an excellent question, actually, because I think parliamentarians, whether it's in the House of Commons or whether in the chamber of the House of Lords, take the job seriously, although time is always a factor, of course. Is it true that every member of Parliament gets the time required to look at every line of every bill? They don't. And we rely on committees of the House to scrutinise the line-by-line legislation. But you do get a fairly strong idea of what the policy of government, whether it's the Tories when they're in government for the last 14 years, or whether it's our government now, you get an idea of where the policy is going and have an ability, I think, to find the bits of the policy and the bill that you oppose. And in opposition, of course, I opposed more than I agreed with. But I do tend to find myself in an awkward position at the moment because I tend to disagree with some of the stuff that the Labour Party are doing in government, or attempting to do at least. So that causes a bit of a difficulty. I mean, look, the reality, I think, as well, is the House of Lords is the grown-up chamber, I think. There's more time, I think. There's people in there who are chosen, not elected. They're appointed for expertise. And whether it's expertise as politicians or former politicians, it's expertise nonetheless. And I think that's important. There's other experts, of course. There's lawyers, retired judges as well. And I think that experience matters an awful lot when it comes to actually looking at details of the legislation, or proposed legislation as it is. And indeed, coming back to the Chamber of the House of Commons, and that's the frustration that this government has at the moment. We have a big majority in Parliament. It's a huge, second biggest majority since 1997. And it's frustrating, I think, for some, that the House of Lords have a tendency to block legislation. But that's the job to do, and it's the job they're supposed to do for me. It's democracy.
You've mentioned timeframes and sort of the speed of, or the lack of time that is sort of within the gift of members of Parliament, particularly in the House of Commons. And we hear a lot about government reform needing to move quickly. Feel free to move into the criminal justice system at this point in terms of answering the question. But we hear about it having to move quickly because it's got to deal with pressure on the system. Why does it matter, though, that MPs or peers stop and ask questions and take the time to, whether it's pick out a particular area and really look at it? Why does that matter?
It matters because it's not about policy for today or tomorrow. It's for the long term. Governments pass legislation. It's forever legislation very often. Some of the stuff in the criminal justice system, which I wished the Labour government in office had never passed, IPP, indeterminate sentences for public protection. We've decided now that it was a bad idea, but we've not repealed the stuff. We've still got people in there who have been convicted of offences which would be worth something, 5, 6, 7 years in terms of sentencing guidelines, who have been in since I was in practice. And I came out of practice from my chambers in Hull, I think probably April 2010. I still have emails from defendants that I looked after who was still serving sentences for what was terrible offences, actually. I'm not suggesting they should be walking out scot-free. These were grievous bodily harm. They were serious offending. But actually, not worthy, in my view, of what is effectively life imprisonment. And that does nothing for rehabilitation. It does nothing for society, in my view. It just costs the taxpayer a lot of money to keep people locked up. But look, the time we afford to legislation is incredibly important. I once said to Boris Johnson that his own legislative advisor, Nicky da Costa, had said he needed weeks, at least, probably months, to debate the Brexit stuff. And I accused Boris of just not affording enough time for it. And I made the analogy that my wife and I had spent longer choosing a sofa than we had to debate the bill. And it was the truth. Me and my missus had been looking for weeks. And I think we had something like 2 days to debate the bill, which was going to exit the country from the European Union. A mistake which I'll not digress, but a mistake that I think we shall forever regret.
You've been really clear. I'm going to move on to juries, which you've hinted at already. You've been really clear that trial by jury isn't just another procedural choice. In plain terms, what does the right to a jury trial and what it protects? What does it mean when you lose that protection? What is severely restricted as a result of the government's current proposals if they come to fruition?
Well, the proposals have, I think, very serious unintended consequences. It's not just the abolition of the right to trial by jury for a good number of either way offences, probably half of offences which on the guidelines are up to 3 years in prison. It's other consequences. Extending the time that can be given in a magistrate's court by way of imprisonment is a concern for me. The idea that if you look at the guidelines and look at offences, for example, I mean, this must not have been intended, but if you look at a domestic-related assault, an ABH, it's an either-way offence. For a first offender or offender who's not been in trouble very often, that defendant would be expected to be advised by a lawyer that they'll get less than 3 years imprisonment. But if it's somebody who's got umpteen previous convictions, the defendant who, and I don't mean to be dramatic, so forgive me, but the defendant who's committed umpteen previous convictions for assaulting people in domestic relationships might well do it the next time and kill them. And in my experience as a criminal lawyer, whether I was a solicitor or at the bar, I saw defendants who had committed violent assaults on partners who eventually committed the ultimate assault, which meant they lost their lives. And I think that's too serious to be rushed. And in terms of jury trial curtailment, I find it absolutely disgusting, actually, that any government would contemplate the idea of taking that right away from somebody who's accused by the state, not guilty of anything, until it's determined that they are in fact guilty of an offence. If you're accused by the state, you should be funded to defend that accusation in the proceedings, and in my view, you should have the right to be judged by peers. My wife's a judge, but I think a judgment is fairly good. But my concern is there is bias. It's unconscious. People are not deliberately biased, but we are biased. And I think a jury of 12 people who are from different backgrounds, economically and socially and financially and in terms of their sort of upbringings and everything else, allows a filter for that bias to be debated and kicked away. And I think that's crucial in cases where the accused, if convicted, could be going away for up to 3 years. 3 years isn't a fortnight in an Airbnb in a place where you wish you'd never booked an holiday. 3 years ruins not just the life of the accused, it ruins the life of his family, of his parents, of his kids, as his partner if he's got one. It ruins the opportunity for him to get employment or her to get employment. It's catastrophic. And for that reason, I think it's utterly despicable that a Labour government led by a human rights lawyer, a man who I've got great respect for, somebody who I call a friend, who campaigned successfully from 1997, Keir Starmer, to abolish single-judge trials for Northern Ireland. 2007, he was successful in that campaign. Now says to me and other parliamentarians, we're bringing them to England and Wales, is utterly disgusting, in my view.
I mean, his argument and ministers' arguments are that the criminal courts are effectively on their knees, close to breaking point, and that these delays are impacting victims and defendants. You make the excellent point, I think, that is often forgotten, that victims and defendants sometimes are the same people, obviously in different cases. But these delays and this close to breaking point narrative is hard. It is not something I think you're arguing about, that the system is clearly in crisis. But is jury trials or stopping jury trials for those less serious cases, for those cases that are going to receive a sentence for less than 3 years, a price worth paying? Why do you find that argument not persuasive?
Well, look, I'm a lawyer by trade, so show me the evidence. And I'm afraid to tell you the evidence isn't there. Look, if I could be persuaded by evidence, I'd say, hang on a minute then. OK, right, you've got people who are waiting, victims of serious assaults and rape and serious sexual assault, who are waiting too long. We accept they are. Is this change going to bring about real change? Is it going to dramatically speed up the process for that victim, if you call them a victim? It's a complainant in truth, and they're a victim when the accused is convicted by a court. But anybody who raises an allegation of assault and rape and sexual assault is a victim. But if those victims are waiting for too long, address the cause. Juries is not the cause. And the tragedy, and the reason I'm so angry, and I'm really angry about this ludicrous policy, is that it's a money-saving exercise. And that's all it really is. And justice secretaries, for decades, have been asked by officials to do the jury thing. And most of them, I think Jack Straw thought about it in 2006, and eventually resisted when, thank goodness, the House of Lords said, not a chance, Jack. Buckland had the opportunity, when in fact the pandemic was a real defence to doing away with jury trials. And he resisted on the basis that it wasn't just. But it's this Labour government. It's the Justice Secretary, David Lammy, who wrote the report for David Cameron, speaking of the consequence of men and women defendants facing single judges in criminal proceedings and what that meant in reality. And that's why it offends me so very much.
What are the other things that they should be doing? What are the things they haven't tried yet? What are the things that should be put in place for?
It gives me, Fiona, an opportunity to be non-party political, actually, because it's not just this Labour government or the previous Tory government. It's been governments for years, for decades, who've underfunded the criminal justice system. It's always been the poor relation. Nobody gets into the criminal law as a practitioner, as a lawyer, to get rich. You go and be a criminal lawyer to keep skin, is the reality. You know, that's the truth of it. It doesn't pay well, whether it's at the bar or indeed as a solicitor. So it's always been underfunded, terribly underfunded. But it's been broken as well by policy. IPP I mentioned. Prison place, I think we're at capacity nearly now. But something in the order of about 89,000 is the absolute maximum capacity. And we're around 86, 87,000, depending on which day you check.
Exactly, yeah.
It's just fit to burst. What rehabilitation's happening in that scenario? What's the education happening? If people need to be getting out of nick, what's the courses that are being provided which are required in order to persuade the probation and indeed the parole board that you're ready to be let out and given a chance to live a life? Those are the things that are underfunded. Policy in terms of allowing the private sector in to make a crust. I'm not some rabid raving socialist, but the reality for me is this. If you give something to the private sector, you're doing it to do it cheap. And when you do it cheap, it goes wrong. And that's the truth of where we are in terms of prison escort. Make no mistake about it. If you've got a four-handed case in the Bailey and one of the defendants is Cat A as opposed to three who are not, the Cat A prisoner gets there on time. Why? Because the police are required to transport. The three other defendants who are accused are going to get there whenever, whichever private sector provider is going to get them to court. You've got courts that are leaking. You've got courts that are just not fit to hear anything. Judges are there and juries are there. We've got a system whereby, I mean, this is just unbelievable to me. I've not checked today's stats, but I'm guessing probably 15 to 18 to possibly even 20% of Crown Court rooms are not sitting today, and that's because the MOJ are directing the courts not to sit to save money. I used to accuse Tories of knowing the cost of everything and the value of nothing. And I'm afraid to say my own government has a similar way about them in relation to the justice system.
Oh, it's I mean, the other stat I was just thinking of as you were speaking is the fact that it's only a little over 2 in 5 trials that actually get to the jury and are effective in the first go round, because so many of those cases are either they what's called crack at the last minute, so somebody might enter a plea to a similar or the actual offence, or they could be ineffective because somebody, a witness or some evidence isn't available. There's so many other things that could happen before.
There is, and that's a part that speaks to the issue of all of the stakeholders in the system are under the cosh. The CPS, there's no reviewing lawyers to review. I remember being on my feet many years ago, instructed by the Crown to prosecute a matter, and I would make a decision. That doesn't happen now. I'm instructed by the Crown. You know, the cases I'm involved with, I mean, I was prosecuting and defending the theft of Mars bars. I'm not talking about wigged and gowned in the Crown Court trying a murder. But I would, if the defence offered something, and I thought it fit the facts, I would use my own ability to decide what difference it made on sentence. And I would take the offer very often. That's not possible now. So you've got a case held up because the reviewing lawyer isn't available to give an answer to whoever's on the feet in a Crown Court or even in a magistrate's about a matter that's before them. I mean, that is the system broken. Because if we could deal with that stuff, there'd be no need to look at addressing juries as a potential money-saving, shortening cases, a money-saving exercise. That's the problem. You could take a lot of waste out of the system without spending too much more money. But you've got to invest if you want it to succeed.
I'm going to move on to what we call Justice North. It's the newest initiative that our charity Justice has started. We've had a report published recently. There's a justice policy debate ongoing in Westminster. We've touched on one of the sort of key areas. What do you see, though, that's missed in that debate that tells you how the system's actually working for those that are not based in Westminster, not based in the south of England? How do you see that communities like yours, you represent Hull East, are represented, I mean, obviously through you, but how are you seeing their voices heard otherwise, and how are you seeing the changes that are happening in the justice system being reflected as to what is needed from those northern communities?
Well, there is an issue. There's no question about it. And I think it is an issue which it's not just in the justice arena, I think. I think it's in a lot of areas of policy where communities north of Watford tend to be ignored a bit. And, you know, the justice system is an important one. Some things are better addressed, actually, because of community involvement. Drugs and reoffending through drugs is well addressed in my area.
Why?
Well, because the former Police and Crime Commissioner, who was a Labour PCC, was a former Chief Superintendent, and he'd started in the police as a copper and worked his way up, and then got a taste for the politics because he wanted to make a change. And Keith Hunter did some incredible work with drugs and rehabilitation and reoffending through drug use. So the Police and Crime Commission put a lot of money in. It's investment again. And it was addressed, and it's coming down. But there's all sorts of other areas where we need to look better at what we do. Look, I'm not going to be sort of saying, I mean, this is certainly not Labour Party policy. But what's wrong with the idea of prescribing drugs? If you've got somebody who's addicted to heroin, what's the point of a methadone course, which means they're going to top up on the illicit substance that they're buying on a council estate or wherever else, and committing crime as a result of having to top up? Why we're not prescribing them so it's done clean? It's done in a controlled manner. It's medicated morphine rather than filthy, dirty smack that nobody knows what's in it, which could kill them and kill somebody else who's incredibly innocent in the scenario. That's the problem, and I think those points need addressing.
So if Parliament genuinely listened to places like Hull, like Liverpool, Leeds, what do you think it would be doing differently in relation to criminal justice now?
Well, if we were prepared to listen to Liverpool, or indeed Hull, to a lesser extent, we wouldn't be doing away with jury trials because there's no backlog. His Honour Judge Thackeray King's Counsel, who was a roommate of mine in Chambers, is running Hull Crown Court rather well. But he doesn't mess around. It's about case management. It's about getting the sides in, the Crown and the defence, and what's outstanding. Tell me, what do you need? Why hasn't the defence statement been served? I want it today. What is his defence? Has he got a defence? Will he have something lesser? It's a Section 4 public order racially aggravated. He's denying the racial element. Will the Crown have a Section 4? He'll plead if they will. Banging heads together. It's about management of cases. That's the same in Liverpool, of course. So if they were listening, London's a problem, of course, but it's a different animal altogether. Not just in relation to justice and the criminal justice system, but in relation to everything. But those models are succeeding. And the policy that we're about to implement, and I don't think we will, frankly, because I'm more confident now than ever that it'll be kicked into the long grass. Why? Because I don't think the Lords will put up with it. I think they'll see that it's an outrage, and I think we'll see that there's consequences which could not possibly have been intended, and they'll just not put up with it. And the Commons will be frustrated because we've not got a policy through as a result of the House of Lords blocking it, and they're not democratic, they're unelected, and all the rest of it begins the debate again about democracy. But actually, it's a safeguard for policies which are not thought through. So I think I've digressed a bit, but I do feel that, thank goodness, we're in a situation whereby the Lords is a filter on the sometimes uninformed policy of government, which is led very often by officials. By the way, I'm not sort of accusing them of being the blob. I'm saying officials advise and ministers decide.
Moving on to scrutiny, and we talked about scrutiny, and you mentioned a minute ago that you thought you might be digressing. I think actually this is linked to what you were saying. Scrutiny can sometimes not be cost-free. MPs who challenge major reforms can face real political pressure. Mm-hmm. What does the current debate tell us about how willing Parliament is to protect constitutional principles when doing so is so uncomfortable? And I appreciate the circumstances with which I'm asking you that question.
Yeah, of course. I mean, it's a good question, and I thank you for it. Look, it gives me an opportunity to explain my scenario. Look, the reality is I was suspended from the whip as a result of my opposition to jury trial curtailment, and what was frustrating to ministers and special advisers was the fact that ministers were saying, I'm told privately, that the problem with Turner is he knows more than us. And that ought not to be something you're fearful of. That should be something that you embrace, in my view. And instead of having the fight, the physical, the fisticuffs, and all the rest of it, you should be sitting down in a room with the people who think they know something and working with them. And that was a frustration to me. So rather than going away quietly and doing as I was told, I was determined to make sure this policy couldn't happen. And I'm sure I'm going to succeed in that. I'm confident it's not going to happen, but it's not because of the work that I've done. It's the work that organisations like your organisation has done, bringing to parliamentarians the evidence, pointing to the stuff that is really factual in the system. That's the stuff that's allowed MPs to look again. It's not going to be one gobby MP from Hull in East Yorkshire who can persuade its organisations like this, which tend to make the difference.
Well, that's very generous of you, but it does matter that the parliamentarians do feel that they can, I think, stand up and say, from the evidence that they've read, what they believe in and hold power to account. And that's part of what our Law for Lawmakers guide is trying to encourage parliamentarians. Been a whole swathe of new parliamentarians that have come through in the latest general election. You're an MP that's been, I was going to say round the block a couple of times, but you've been in Parliament for coming up for 16 years.
Yeah.
If a new MP or when a new MP comes to you for advice in terms of how to get right their job in Parliament, whether it's scrutinising, whether it's trying to make better laws, what advice would you give to them, particularly in relation to pressure and headlines and that sort of thing?
It's probably unlikely because I suspect the whips are saying don't go anywhere near Turner.
Okay, forget that.
But
go back.
But joking apart, I did have an MP text me yesterday evening, as it happens. I've never had a conversation with him, ever, in fact, but I know of him, and he's in a seat which is vulnerable to reform. And he texted me out of the blue as I was travelling down and said, look, what do we do tomorrow? Now, this recording is important, I think, in terms of timing, because I'm going back to the chamber now with a view to speaking in a debate on scrutiny of the Prime Minister and his decision to appoint Mandelson and whether, in fact, he's misled the House of Commons. I don't think he's deliberately misled Parliament. It's just not his style. It'd be like me waltzing into a Crown courtroom with the wig and gown and deliberately knowing misleading the judge. It's just not something Keir Starmer would do. But there are inconsistencies in what he said in his answers at Prime Minister's questions last week, as opposed to what Holly Robbins, the now dismissed senior civil servant in the Foreign Office, said to the Committee of the Foreign Affairs last week. So I say that should be scrutinised. I say there should be an inquiry. The privileges and the standards rather and privileges committee exists for a reason. It's about saying, You've got a massive privilege being a member of Parliament. It's not just the fact that you've got the opportunity to go into that palace and, sashay around like a sort of loaded gentry. That's not a privilege. The privilege is representing people. And the privilege as well is a legal one. Go into that chamber and say whatever you think. But you've got to be cognizant of what you're saying there has got to be true in what you believe. And you shouldn't be telling half a story. If I go in there and state a stat, it might be something that I've read from one of your reports. But if I've got it badly wrong, I go in there and I correct the record. Why? Because we have a privilege, but it's a legal privilege as well. And we mustn't mislead, inadvertently or otherwise. And if we do, we should correct it. And that's the challenge for the debate today, whether the Prime Minister should face that scrutiny. I think he should. I think it's a bad idea trying to avoid that. And I think the politics of that are very bad as well. And that was why the Member of Parliament texted me and said, what do you think I should do? My answer was, do what you think is right. And that's what I always say to colleagues. Do what you think you can live with. And, I very often think to myself, have I done the right thing? And the gauge for me very often is, what would my daughter think? Not now, but when she's old enough to know. What would she think of the way I've approached policy? Would it be acceptable to her? Because it's acceptable to society. And that's what keeps me, I think, in the right direction. Sometimes I get it wrong. Most of the time I think I reflect the views of people in the constituency I represent, but I don't do it on the basis that I want to sort of make them happy. 74% of my constituents voted leave. I thought it was the worst idea the country had ever contemplated. And I think I'm going to be proven right. The evidence is there already. So I didn't go in there and say it was a great idea to leave the EU on the basis that my constituents wanted to be out. I made the argument with my constituents, and I made the argument with Parliament. And I tried to persuade others to understand what I thought the implications of that were on them. And I think it's already becoming apparent that that decision was a decision we already regret.
Carl, thank you so much. We've
Thank
covered
you.
a huge amount of ground.
Yeah.
It's been an absolute pleasure talking to you. Thank you.
Super. Thanks, Fiona. It's been a pleasure as well. Thank you for what you do.
Thank you, Carl, for being with us today and for such a thoughtful discussion. I know our listeners will have valued your insights on parliamentary scrutiny, the right to a fair trial, and the importance of protecting fundamental safeguards within our justice system. Thank you for listening to Law for Lawmakers. We designed this guide not just for parliamentarians, but for anybody who cares about the rule of law, whatever your background. To learn more about our work and to access the guide, please visit www.justice.org.uk. And if you found this episode insightful, like, subscribe and share it with your friends, family, colleagues, anyone who cares about the future of our justice system. I look forward to speaking to you on the next episode.